So now we're going to start looking at some civil rights issues with women and women having control over their bodies and being treated equal with men under the law. And those are their civil rights that they're going to look at. So one of the cases we're going to talk about, which is very controversial today and in many people's minds. However, it set precedent, and it's been the precedent since 1973, is Roe versus Wade. So it's been the example on how the Supreme Court's going to approach abortion. Now, in Roe versus Wade in 1973, it's a landmark decision by the United States Supreme Court on the issue of abortion. And basically, what happened is when the court ruled 7-2, which is a large majority, that women have a right to privacy under the Due Process Clause of the 14th Amendment, extended to a woman's decision to have an abortion. But this right must be balanced against the state's interests in regulating abortions. So this is a right that women have over their body. And what we find with the government is that the body is kind of hands off for the most part. So the Supreme Court basically said, look, the Bill of Rights and the Constitution protects an individual's body from the government. And people might be like, well, that's oversimplifying it. And I understand what you're saying, but that's important because it sets up other issues in the future when maybe you would want to have things like a chip or something, like the government want to put chips or something in your body, or for location or prisoners or so forth or so on. So women have rights over their body, and since it's their body, the government cannot stop them from choosing to have an abortion. Now, the problem is, after it says that they have this right, it basically leaves the door open to how do you interpret that afterwards. And that's why you have some states where women can have an abortion 6 months into a pregnancy. And then you have some states where, they barely have an abortion 2 months into a pregnancy. So more conservative states have made it really difficult for women to have abortions. And there's other ways of doing it as well. Like, for example, in Missouri, we really only have one public abortion clinic in the entire state, which is the one and they tried to close it down on Lindell, kind of by SLU. And sometimes you'll see people out there protesting, and there's been more protections given to protesters as well. People can get closer to women trying to go into the clinic. And I've heard stories from women mostly what the clinics do, like Planned Parenthood, which is the one I'm talking about, is the women go in there and they do things like they have a free checkup for their a woman's needs. And you have people screaming at you at the door about abortion, and over 90% of what they do is actually, they do education and medicine for everything other than abortion. That one does happen to actually perform abortions, and that's why it's such a debated area. But not all Planned Parenthoods, and most do not. Now, protecting women's health and protecting the potential of human life. So this really brought in a lot of other questions, because the question was, is a fetus a child, and does the rights of the fetus outweigh the rights of the mother? And then the argument is, no, it's not a fetus, it's a baby. And the next question is like, well, when does life start? And these are very complicated arguments people have had. And they'll say everything is, well, as soon as an egg is fertilized. Well, if that's happened, then women have abortions all the time, because your body naturally aborts the child, or you'll have women have many miscarriages. So are those abortions? Well, that's naturally what happens too. So this gets into very complicated moral and philosophical arguments on what your perspective is. However, the government says no. The woman's rights over her body are more important than anybody trying to define the pregnancy itself. Now, the question is, at what point when does the fetus become a baby or have rights as well? And that's where it gets, is it an embryo? What is it, and at what point is there enough growth? People say, oh, it's a heartbeat. Well, other people would say brain development. There's a lot of ways. But also you have other issues like women's health. Like, when do you need to have an abortion to save the woman? If the woman can't have the baby without dying, should we always choose the woman or the mom's life first? And there's some people who have argued the opposite. No, we should let the baby live and the mother pass away. Well, is that infringing on the mother's rights? So it gets very complicated very quickly. So under Roe versus Wade, you got this argument. The 14th Amendment declares that the states may not deprive any person of life, liberty, or property without due process of law. So we're going back to the 14th Amendment and the Due Process Clause. So you can't arrest a woman and infringe on her rights over her body. The states can't do this because she has an abortion. That's not true. You cannot do that. And that's what the court does. And it sets this battle that it still exists today. And we know that political parties have divided and they've used this to energize their parties. Like the Democrats are very Roe versus Wade. They're much pro-choice and they're about women have rights over their bodies. And also about 65% of the Democratic Party is women. On the other side, you have the Republican Party has really latched on to pro-life and said, no, this is totally up to the states. And, it's a life as soon as it's conceived, and depending on where you're at in the United States, you can't do this after a week or two or a month. And you bring in other questions and like, what do you do with teenagers that get pregnant? Who makes those decisions? There's other issues like, well, if the father, is he a part of the decision on the abortion? And that gets into other arguments that you can form your own perspectives on. But we're trying to understand this case and how the Supreme Court ruled, and this really changes and gives women some power over their bodies. The next case is Ledbetter versus Goodyear Tire. And this is a very important case as well. What we're going to find out with this case is, unfortunately, it never completes itself, and we're going to find out why. So the Equal Pay Act of 1963 is the United States labor law amending the Fair Labor Standards Act aimed at abolishing wage disparities based on sex. It was proposed by John F. Kennedy as part of the New Frontier program. There's this idea that men and women could not be discriminated based on their sex, if they're born male or female. Remember, sex is you're actually born male or female. Gender is the social construct that you identify as more of a male and more masculine or female, and usually feminine, but people see those traits as balanced in different ways, depending on their perspective. But it's the actual born with the parts, your physical parts. Now, the issue compared to worth, paying women equal for jobs similar to those held by men, was challenged in 2007, the Supreme Court case of Ledbetter versus Goodyear Tire and Rubber Company. And the case was thrown out because of time restrictions. Unfortunately, we don't know what would happen because it basically when you have a lawsuit or laws, things will time out and then the case will be pushed out. Now, this is still an incredibly important case because it really gives us an idea and leads to other things like more laws to protect women and push for equal treatment. So basically what happened is Lily Ledbetter worked for Goodyear Tire, and she'd worked very hard. She was a great worker, and she worked her way up at the factory in the South, I believe it was Alabama, and she became a manager and was moving up the ranks, and she found out from her coworkers that they were making more money than her. And she had started before and sometimes the exact same time as other people. However, they were making more money than her, and the only real difference was their sex. They were men and she was a female. And this case, unfortunately, doesn't play out in the end, but it shows how important discrimination is. And I have seen actually a case in Noah where a college female professor was hired at the same time as a male professor, and they had the exact same qualifications. And within several years working at the university, and you think about how progressive universities can be, the woman was making less money than the man, and she sued and won the case on discrimination basis. So we have to understand that this case sets up precedent for women's rights, and it's an important case, and it leads to laws and legal actions taken by Congress to treat women equal. So now we're going to move on. I might have to actually escape this real quick. Okay, to Title IX. And Title IX is also a very important, this is a very important civil rights law. This is equal treatment under the law, where abortion, if it's interpreted under the 14th Amendment, and that would be a civil liberty. If it's in the Bill of Rights or it's interpreted according to the 14th Amendment, that's a civil liberty. where Title IX, it has to do with civil rights issues. Lilly Ledbetter, it's a civil rights, equal pay based on gender, or sex, I'm sorry. So under Title IX of Education Amendment in 1972, Title IX is this idea that you have to be treated equal at a public schools. At schools, no person in the United States shall, on the basis of sex, be excluded from participating in or be denied the benefits of or subject to discrimination under any education program or activity receiving federal financial assistance. So public schools receive quite a few dollars from federal funds. So that's why you don't have single-sex public schools. And some people will say, well, wait. Isn't there an all-girls charter school in St. Louis? And the answer is yes, there is. However, I think you have a pretty strong argument that it's a civil rights issue, that they can only let female students go to that charter school because they do receive if they receive federal funding. Now, I don't know. Maybe they don't receive federal funding. If they do, the reason it probably still exists is because nobody sued them or challenged it. If nobody challenges laws and nobody moves forward on these civil rights and civil liberties issues, nothing happens. You're going to have to be willing to move forward. So one way we see this is that also schools are balanced. You have male, females attend public schools and universities, but the availability of athletic teams and scholarships should be equal for men and women too. So that's why there's this rule that if you have 9 boy sports, there should be no more than 1 or less female sports. So they can have 8 female sports or 11 female sports, but you can't have like 2 female sports and then 10 male sports. That is discrimination under Title IX. And Title IX is equal treatment under the law for women. Women in schools and any place that receives federal funding, which is a lot of places. So it prohibits sex discrimination in education. Schools must have established procedures for helping victims. Like, what do we do to help females that are or males that are mistreated? It can work the other way for males as well. You can't have a school where it's predominantly like female and they only have 5 sports for the males and 10 for the females. So it's meant for treatment overall, but obviously it started in 1972 with concerns about women because women are usually discriminated much, much more on the legal level in schools and the workplace than men could ever imagine. It applies to both genders. Schools must be proactive to create a campus free of sexual discrimination. And then this could actually be applied in other ways that we talk about. We start to get into complex arguments about gender and gender identity. Can that Title IX cover that? And there have been arguments. So you will see male cheerleaders, and there have been we have females that that were born female but identify as male that are on the wrestling team or vice versa. And that is covered a lot of times and argued under Title IX laws and federal law.